The front one doesn't work again. I didn't hear it. Okay. So, are we all here?
Yes, my lord.
Hello?
Yes, my lord.
Hello, Leonard Council.
Good day, my lord.
My lord.
Good afternoon. I didn't know you're out here.
Yes, my lord.
A very long time, my lord.
You can see my face now. But
Yes,
I
my
can't
lord.
see yours. However, you can hear me.
Yes.
I don't know if
Yes, we can hear.
Mr. Ate is here. Triumph or Ate.
Yes, my lord.
Mr. Daniel, keep.
Yes,
Mr.
my lord. I'm
Ate,
very,
or
very
somebody
present.
representing him or her.
Yes, my lord. How do you hear?
Yeah. So, you know, today is call up the matter is not yet. Sorry, just wait a little bit. Let me get the case file so that they call up the matter and we start the judgment.
Okay, my lord.
As the court pleases.
Thank you. Barnabas. Please, can I make it, do it for me so that I will sing it. So, since you are all here, please call up the matter, registrar. Give me that. Thank you. Yes. Case number N31 between Mr. Bassi Okon Imanu and the Total Industrial Limited. Two, Chief Fence, Assistant General Manager, AD Ethiopia Industrial Limited. Three, Department of State Security, USA. My lord, parties are absent. I see. Parties are absent. Yes.
Please, my lord. Try Ate.
Okay.
With me, Kelvin Tiku for the claimant.
Triumph.
Ate.
Are you the same as Triumph Paul Ate?
Yes, my lord.
Okay.
With me, Kelvin Tiku for the claimant.
With
Kelvin Tiku is spelled Tiku for the claimant.
Okay. Yes.
May you please, my lord?
Who else?
Daniel Keep, my lord.
So who else?
Please,
My
my
lord.
lord.
Yes.
I have third defense.
Please put it up. You can answer it. Yes, Esquire. Are you appearing alone?
Yes, my lord. I'm taking the also for the third defense.
All right.
My lord, my name is Daniel Kip.
Okay.
My lord, I humbly appear for the first and second defendants.
Okay. Very well. This is we have the judgments. I hope you have all the time to yourself because this judgment is a little bit lengthy. I don't know how you will have us do it. Do I read all of them word for word, or do I read the beginning and the end? But since
Lord,
I have all the time, I don't know about you.
My Lord, for us, we will prepare the beginning
Yes.
because we will be having school runs to pick our children from the school.
I thought as
Yes,
much.
my Lord. So just because since we will be privileged to also have copies of the said judgment, I think the beginning will be better.
Very well. Thank you. So this is a judgment. Clement instituted this action against the defendants by the form of complaints, accompanied by statements of facts filed on the 10th day of May 2017. The claimant was employed as a bulldozer excavator operator by the first defendants. The claimant, sometime in March 2017, challenged the second defendant, the assistant general manager of the first defendant, as to why he was marked absent from work.
My lord, your mic has gone off.
Okay. The claimant, are you hearing me now?
Yes,
my lord.
The claimant substance in March 2017 challenged the second defendant, the assistant general manager of the first defendant, as to why he was marked absent from work on the 15th day of March 2017, when he did come to work. The said confrontation led to the issuance of a query to the claimant, and subsequently he was arrested and detained for a day by the third defendant. The claimant has now approached this court seeking the following: A declaration that the purported dismissal of the claimant by the first and second defendant is unlawful, as it contravenes Articles 23 and 24 of the Negotiated Conditions of Service for Workers of BSA Plantations Limited and Ayop Industry Limited, in quotes. B, a declaration that the purported dismissal of the claimant by the first and second defendants is illegal, null and void, the defendants having failed to comply with the laid down procedure as contained in the said Articles 23 and 34 of the, quote, Negotiated Conditions of Service for Workers of BSA Plantations Limited and Ayop Industries Limited, unquote. C, a declaration that the arrest and detention of the claimant by the defendant is unlawful and contravenes the provisions of Section 34 and 35 of the 1999 Constitution as amended, and also the Negotiated Conditions of Service for Workers of BSA Plantations Limited and Ayop Industry Limited, agreed between the Agriculture and Allied Employees Union of Nigeria, and the management of Biase Plantations Limited and Ayop Industry Limited. D, payment to the claimant of his full entitlements at the rate of 800 naira per annum per day from the 6th day of April 2017, being 24,000 naira per month and 288,000 naira per annum until judgment is delivered in this matter. E, and payment to the claimant of his annual leave allowance at the rate of 28,800 naira per annum for the period beginning from 2012 to 2017, totaling 144,000 naira only. F, general damages of 25 million naira only for the arrest and detention of the claimant by the DSS at the instance of the first and second defendants from the 4th day of April 2017 to the 5th day of April 2017. The first and second defendants, upon receipt of the claimant's originating processes, filed this memorandum of appearance, statement of defense, counterclaim. In their counterclaim, the first and second defendants, counterclaimants, are seeking the following against the claimant defendant to the counterclaim. A declaration that the termination of the contract of employment between the first and second defendants, counterclaimants, and the claimant defendants to counterclaim to the counterclaim by the claimant defendants is unlawful and wrongful. B, the sum of 24,000 naira as damages for the wrongful termination of the contract of employment, being the 1 month salary in lieu of notice. C, general damages in the sum of 20 million naira for breach of contract of employment. D, the sum of 1 million naira only, being special damages for the cost of defending the suit and prosecuting this counterclaim. E, 10% current bank interest rate per month on the judgment sum until the same is liquidated. The third defendants, equally with leave of court, filed this memorandum of appearance and statement of defense. The claimant, in response to the first and second defendant's statements of defense and counterclaim, and the third defendant's statement of defense, filed separate replies to the statement of defense and the defense to the first and second defendant's counterclaim. Trial. Hearing commenced on the 18th day of October 2017, with the claimant testifying as CW1. He adopted his written depositions as his evidence in chief. Through him, 4 documents were tendered in evidence, admitted and marked exhibits C1 to C4 respectively. C1 was cross-examined by the counsel to the first and second defendants, as well as counsel to the third defendants. Thereafter, the claimant closed his case. For the first and second defendants, one Stephen Ebong, the head of human resources of the first defendant, testified as DW1. He adopted his written depositions as his evidence in chief, and DW1s were duly cross-examined. After a number of issues, the matter was later adjourned to enable parties file and exchange their respective final written addresses. The first and second defendants' final written address. The first and second defendants filed their final written address, wherein they formulated 3 issues for determination, to wit, A, whether the claimant has revealed a course of action as to activate the jurisdiction of this court. B, whether from the totality of the facts of this case, the claimant has proved his case to be entitled to relief sought. C, whether from the totality of the facts of this case, the first defendant counterclaimant has proved his case to be entitled to the relief sought. Now, the next thing is the submissions of the first and second defendants on the issues that they formulated, which is what I'm going to jump through, because the next one is a paragraph on the issue number 1. Then the next is issue number 2. And then also issue number 3. These issues were argued, and so many cases were, a plethora of cases were cited to support them. So at the end, it was noted that the counterclaimant's evidence was not challenged or controverted. That is what the council is saying. And the council urged the court to dismiss the claims of the claimant and grant the relief sought by the counterclaimant. Now, the third defendant, in his final written address, formulated an issue for determination, and that is whether the third defendant can be held liable for the dismissal of the claimant by the first and second defendants. He was very brief in his address, because he submitted that the third defendant is not the employer of the claimant and does not take directives from the first and second defendants, cannot be held liable for the dismissal of the claimant, and that by virtue of sections 1C and 3A of the National Security Agencies Act number 19 of 1986, the third defendant has the responsibility of crime prevention, detection, and investigation against the internal security of Nigeria. It acted within its powers. The learned counsel for the third defendant urged the court to hold that the third defendant is not liable for the claimant's dismissal and dismiss the suit with substantial cost. The claimant, in his own final written address, formulated a sole issue for determination, and that is to say, was the manner in which the claimant was dismissed from the employ of the first and second defendants by engaging the third defendant to arrest and detain the claimant amount to global best practice in the labor sector, and if in the negative, whether the claimant is entitled to all the reliefs herein sought. Then the council submitted that the modus operandi adopted by the first and second defendants in disengaging the claimant is against known global best practice in the labor sector. It cited the case of Adedeji versus CBN, reported in 2023, citation fully supplied, that the first and second defendants did not comply with the provisions of Exhibit C4, that is a condition of service. To him, gone are the days of unchecked hire and fire practice. Labor law has evolved beyond that, citing the case of Ebere versus Diamond Bank PLC, reported in 2015, citations fully supplied. Then council then urged the court to grant the claimant's reliefs. Now, in the resolution, having regards to the facts and circumstances of this suit, the processes filed by the respective parties, the evidence adduced, and the submissions of counsel, this court distills the issue below for determination, and that is to say, in view of the evidence adduced by the claimant, has he discharged the burden of proof required by law to entitle him to grant this relief? B, has the first and second defendant counterclaimants proven their case to entitle them to the relief sought? Now, the court now went to town on some of the legal principles, like it is the party who asserts the existence of certain facts to call, that should produce credible, cogent, and convincing evidence on the balance of probabilities. Gentlemen, I'm going to leave all this because all these are all what we all know, but the courts really mentioned them so that at the end, the reasoning of the court on whatever decision it makes will be known. So I'm going to leave this because the court was just taking what each and every learned counsel said one by one. And even though the court was making up its mind as we went, as we she went on, like saying, I therefore find and hold that the claimant has, in his pleadings, stated his grievance against the defendants. The alleged violation of his civil rights to maintain an enforceable claim against them. The issue of substantiating his claims with evidence does not arise at this stage. It is for the court to review and evaluate the evidence adduced and reach a decision one way or the other. Learned counsel to the first and the second defendant counsel's submission in this regard are overruled and hereby discountenance, and I so hold. The court really went to town on what everybody said and evaluated them and agreed with them and overruled some of them, few of them. And because of what we have agreed, the court is not going through the whole hog of the 29 pages of this. So then I will start from page 22 and I will run through it. In the case of Oforishe versus NGC Limited, reported in 2018, citations supplied, the Supreme Court on the issue of when salary in lieu of notice becomes payable held inter alia, and I quote, when a contract of service gives a right of termination of the contract by either party, the party seeking to put an end to the contract must pay to the other party the salary in lieu of notice at the time of termination of the contract. Where this is not done, the termination of the appellant's employment will be unlawful, etc., unquote. CW1 did not comply with the requirements set out at clause 9 of the employment letter, that is Exhibit C1, and Article 34(1) of 2 of the first defendant's condition of service. Exhibit C4, in disengaging from the first defendant's service, as he did not give a month's notice or pay salary in lieu thereof. The court therefore finds and declares that the termination of the contract of employment between the first and second defendant counterclaimants and the claimant defendant to counterclaim by the claimant defendant is unlawful and wrongful, and I so hold. The counterclaimant's relief number 2 is for the sum of 24,000 Naira as damages for the wrongful termination of the contract of employment, being 1 month's salary in lieu of notice. The CW1 was expected to give a month's notice to his employer, the first defendant, of his intention to disengage from his service or in lieu thereof, pay the sum of 24,000 Naira, being his 1 month's salary. The CW1 gave evidence under cross-examination when he stated, and I quote him, "It was the arrest that made me know that my appointment has been terminated," unquote. CW1 was arrested on the 4th day of April 2017 and detained till 5th day of April 2017 when he was released on bail. According to him, he went to work on the 6th day of April, but was told to hand over the keys to the bulldozer and leave the premises. DW1, however, states that the company never dismissed the CW1. Rather, he absconded. CW1 thus failed to honor his contractual obligations set out in his letter of employment and the first defendant's condition of service. He is bound by the terms of agreement voluntarily contracted by him. His interpretation of his arrest culminated to termination notwithstanding. Having thus failed to give the required 1 month's notice of salary in lieu of notice, as required by clause 9 of CW1's letter of employment and Article 34 sub 2 of the first defendant's condition of service, this court hereby orders the claimant defendant to the counterclaim to pay the first defendant counterclaimant the sum of 24,000 Naira only as damages for the wrongful termination of the contract of employment, being the 1 month salary in lieu of notice, and I so hold. Relief number 3 is for general damages in the sum of 20 million Naira only for breach of contract of employment. The counterclaimant has not shown any pecuniary damage or injury the defendant to the counterclaim's action in leaving its employment cost it. Besides, it has sought and has been awarded damages in the sum of the defendant to the counterclaim's salary in lieu of notice. So awarding general damages would amount to double compensation, which the law frowns at. In the case of UBA versus Chinyere, reported in 2010, 10 Nigeria Weekly Law Reports, Part 1203, page 453, it was held that where, however, the court finds that the termination of a contract of service is wrongful, the measure of damages the plaintiff would be entitled to would be salaries for the length of time during which the notice of the termination would have been given in accordance with the contract of employment. The court, having awarded damages in favor of the counterclaimant in the tune of to the tune of 24,000 naira, being the defendant to the counterclaimant's 1 month salary, cannot allow the counterclaimant to take a second bite at the cherry or eat his cake and have it. The counterclaimant, having failed to call or produce credible and convincing evidence that shows the pecuniary injury or damage to the defendant's to the counterclaimant's breach of the employment contract occasioned it, cannot be allowed to be doubly compensated. The claim accordingly fails and is hereby dismissed, and I so find and hold. Relief number 4 is for 1 million naira. These special damages for the cost of defending the suit and prosecuting this counterclaim. In the case of Vital Investment Limited versus CAP PLC, reported in 2022, citation supplied, the Supreme Court had this to say on the issue of strict proof of special damages, and I quote, strict proof of special damages consists of evidence of particular losses which are exactly known or accurately measured before the trial. Strict proof implies that a plaintiff who has the advantage of being able to base his claim upon a precise calculation must give the defendant access to the facts which make such calculation possible. See also British Airways versus Atoyebi, reported in 2014. Citations fully supplied. The counterclaimant, in proof of this leg of his claims, tendered in evidence Exhibit D1, which is a receipt issued by the firm of Atta Ochinke and Co. to the counterclaimant in the sum of 1 million naira being professional fee for litigation in Basiokon Emmanuel versus Ayop Industry Limited. However, in the case of Keystone Bank Limited versus Abu Ghafaru Yusuf, reported in 2021, citation supplied, the issue of whether a litigant can pass on the burden of counsel fee to the opponent in the action was considered, and the Court of Appeal was emphatic in its view that where the claim is not founded on the course of action before the court, such a claim is outlandish and should not be granted or allowed. The law requires a claimant who is making a claim for special damages to lay before the court concrete evidence demonstrating in no uncertain terms, easily recognizable, the loss or damages it has suffered, so that the defendants and the court as umpire would readily see and appreciate the nature of the special damages suffered and being claimed. A damage is special in the sense that it is easily discernible and quantified. It should not rest on a puerile conception or notice, which will give rise to speculation, approximation, or estimate of such fractions. See the case of UBN versus PLC versus Chimeze. It was reported in 2014, LPELR 22696. It's a Supreme Court case. The defendant to the counterclaim had in his defense to the counterclaim stated that the counterclaimant was stingy and could possibly not have paid the sum of 1 million naira as professional fees This averment clearly violates the rules of pleadings. Pleadings are not to contain arguments. The defendant, other than state this, did not deny or lead evidence to controvert the counterclaimant's claims. This claim, therefore, succeeds and is granted. The counterclaimant is awarded the sum of 1 million naira, being special damages for the cost of defending the suit and prosecuting this counterclaim. I so hold. Relief number 5 is for 10% current bank interest rates per month on the judgment sum until same is liquidated. Order 47, Rule 7 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 provides thus, and I quote, the court may, at the time of delivering the judgment or making the order, give direction as to the period within which the payment is to be made or other act is to be performed, and may order interest at a rate not less than 10% per annum to be paid upon any judgment. The counterclaimant has sought for 10% current bank interest rates per month on the judgment sum until same is liquidated. The rules of this court gives this court discretion to award not less than 10% interest per annum upon any judgment sum. This leg of the counterclaimant's claim is clearly outside the purview of what the rules permit it, accordingly fails. It accordingly fails and is hereby dismissed, and I so hold. In all, the first issue for determination is resolved in part in favor of the claimant against the defendants. Similarly, the second issue for determination is resolved in part in favor of the counterclaimant against the claimant defendant to the counter claim. For the avoidance of doubt, except as set out below, for purpose of clarity, all other claims of the claimant and the counterclaimant fail and are hereby dismissed. The court declares and orders as follows. 1. It is declared that the arrest and detention of the claimant by the third defendant at the instance of the first and second defendant is unlawful and contravenes Section 35 of the 1999 Constitution of the Federal Republic of Nigeria. Make it. 2. The sum of 2 million naira only is awarded jointly and severally against the defendants for the unlawful arrest and detention of the claimant by the third defendant at the instance of the first and second defendants. 3. It is declared that the termination of the contract of employment between the first and second defendant counterclaimants and the claimant defendant to the counterclaim by the claimant defendant to the counterclaim is unlawful and wrongful. D. The court hereby orders the claimant defendant to the counterclaim to pay the first defendant's counterclaimant the sum of 24,000 naira only as damages for the wrongful termination of the contract of employment, being 1 month's salary in lieu of notice. E. The counterclaimant is awarded the sum of 1 million naira, being special damages for the cost of defending the suit and prosecuting this counterclaim. No order as to costs are being made. Parties are to bear their respective costs. And this is the judgment, and it is entered accordingly.
As the court pleases.
Very well. This is the only one here. Ika. This had a sister case. What's the sister case to this?
So the consolidated should be Lord.
Okay, they were consolidated.
Be Lord.
The consolidated case. Okay. Gentlemen, this is the judgment, and you will get this as soon as possible.
As the court pleases.
Yes. Okay. The court shall rise. This picture.